What's up, everybody? Welcome back into another episode of The Lawyer You Know. Not much of an intro needed here. The civil lawsuit Karen Reed has filed against Proctor, Tully, Buchanan, McCabes, Alberts, Higgins, all of them has dropped. We are going to read through it together. We are going to focus on the details that they explain for the very first time, I feel like, in black and white, exactly what they believe happened that ended the life of John O'Keefe. We're going to talk about some of the comments made by the lawyers, some of the other news in Massachusetts today. Get ready. It's going to be a long one. Make sure you guys hit that like button and make sure you're subscribed because there's a high likelihood that this turns into a two-part video and you're not going to want to miss either part. So this lawsuit is 46 pages long. It's pretty long. There's a lot of details. I thought about the different ways that we could break this down. My first thought was I could summarize it. A lot of these facts we've heard before in kind of different parts and parcels. But the more I read it, I thought it just is kind of easier to get through. If we see the timeline the defense lays out, I call them the defense. I'm so used to them being the defense. They're the plaintiffs here. Karen Reed's team lays out a timeline and they weave in the facts and the details that we already know. And they use inferences from the evidence that we know to prove their point in their version of the events. It is so very different being on the offensive in a civil claim like this versus on the defensive side of a criminal case. And we pointed that out a million different ways throughout the criminal side of the trial. So we will be reading every word of this complaint together. If this video goes to I think I have an hour and 45 minutes, maybe 2 hours. We'll see how much of it we get in. If we get all of it, great. If not, we'll save some for another video because there are also some other things happening in Massachusetts today that some directly affect this case, some do not. I'm going to get to some of those today. Some of those will be saved for another video. Of course, I will answer as many of your questions as I possibly can. You guys know my voice will get completely shot if I do this for 2 hours. So we have our favorite special guest reader that is joining the class again, John Nizer, the producer of the show, the man behind the curtain here, kind of like the Wizard of Oz. John, thanks for doing the Lord's work here today.
Hey, glad to be here.
So John is going to be reading the words on the complaint. I will be interrupting him a ton to give my reaction and analysis and talk about how these facts fuse into the causes of action. I will stop to answer your questions as well. I'll be able to follow the chat while John's reading, which is awesome because when I have to read it myself, it's impossible for me to follow the chat. And I'm also going to stop to talk about some of the comments made by the lawyers involved here, right? Because we had comments for the lawyers from the Albert Higgins crew, and we had comments made by Alan Jackson. I will pause, give us some breaks throughout, give John a little break throughout, and talk about what those comments are. So when we first look at this lawsuit, the most important thing for us to look at is who is included and who is not included, okay? And Karen Reed obviously is the plaintiff. The defendants are Michael Proctor in his personal capacity, and that's important. Sergeant Yuri Buchanan in his personal capacity. Lieutenant Brian Tully in his personal capacity. Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, all the usual suspects. No Colin Albert, none of the quote-unquote kids. And we'll talk about exactly what that means as we get through the allegations in this complaint. But it's important to understand that. And something else right off the bat that was interesting to me is it looks as if, based on the service of this document, that the McCabes, Alberts, and Higgins all have one lawyer. The law enforcement officers involved don't, even the former officers, don't have the same lawyer. It looks like they might not have a lawyer yet, but they all have one lawyer. To me, there's an obvious potential conflict of interest for all of these people turning on each other, having evidence against each other, or telling them, we're going to try to block this discovery for this client because it might be bad for that client. But if it's good to turn over the discovery for this client, how are you as a lawyer going to make those decisions and differentiate from those? Will they hire separate lawyers? Does this add to the whole civil conspiracy? That's not going to be something that comes up in trial like, oh, you all have the same lawyer. But sometimes jurors notice if the same lawyer is representing all of them, does that actually look bad for that entire side of the V? Very interesting to me. And from my perspective, that's something we're going to keep an eye on, exactly how this battle is done. And a lot of this that we're going to hear about is intentional misconduct, which means not insurance footing the bill. So are all these people paying for lawyers themselves? And where is Karen Reed going to get the money from? Is there some hook? If she gets law enforcement involved, that it gets the sovereign involved, and then we go that route to get money. We'll kind of dig into that probably at a later date because we have plenty to get to. Ashley, thank you for sending this one to me. A bunch of you guys sent it to me. Thank you so much for everybody that sent it to me. I really appreciate you guys tagging me and all the stuff happening today. And Walsh, in this case, in the new potential DA, which we may touch on in this stream, and see what you guys that are all from that area think. So, John, let's get to it, starting with the introduction.
Oops. Did you want to read through these names or anything like that? Or you?
Yeah, I just did. So
Okay.
You're good.
Okay, cool. All right, here we go. Introduction. For 3.5 years, plaintiff Karen Reed was wrongly accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police, MSP, and those working in tandem with the MSP. To shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III, now after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who objectively failed to ensure that justice was sought and served in the aftermath of January 29th, 2022.
All right, so pause for a second.
Go ahead.
So paragraph number 2, right here in black and white, is Karen Reed's description of what she believes and her team believes. And she wasn't there, right? That's going to be her allegation this whole time, is I was not inside, so I didn't see what happened. But all of the evidence did a couple things that we saw in the criminal trial. It proved what could not have happened that night, a la a car accident. And it also proved what did happen. That's what they're saying. That's their allegation. And we start to get that here in paragraph 2 right off the jump.
Paragraph 2, Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed in the defendants Brian and Nicole Albert's home at 34 Fairview Road in Canton, quote-unquote house, in an altercation during a late-night house party with other defendants, collectively the house defendants, after a night of heavy drinking. The house defendants responsible for Mr. O'Keefe's death, some of whom had professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders for help, among other actions, the House defendants conducted a Google search for information about how long to die in the cold, moved Mr. O'Keefe's body outside and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle and that he died in the snow without ever coming into the house that night. Mr. O'Keefe's body remained in the Alberts' lawn until Karen Reed found him later in the morning.
All right, so pause for a second. So basically, no real surprise, but this is their allegation of what happened. He was killed inside the house. They put him on the lawn to make it look like it was a car accident. They knew how to do this. They were Googling things that prove this, okay? And it's very interesting to see this in black and white because my mind is also thinking about the potential defamation claim that we've heard is coming from the defendants in this case to Karen Reed and Turtle Boy. And truth is obviously an absolute defense, but it also has to be something that they knew was false when they were saying it. And it seems very clear, right? You can't use court filings and lawsuits as a means of defamation, but it's very clear that they believe this is the truth and this is what they're saying. So if you're believing that it's the truth and it's what you're saying, can it really be defamation? Is it something that you did on purpose? Is this a factual lie that you told? Or do you truly believe it and you have evidence to back up your reasonable belief that this is what happened to John O'Keefe? And to me, that's very, very interesting. Let me read this comment here. Lisa said, please keep my husband Darren in your prayers. He was diagnosed with cirrhosis of the liver in 2021, and he's now going to Duke transplant to be added to the list of liver transplant. Thank you all. Lisa, absolutely. We will be praying for your husband, Darren, for his transplant. That's, I know it's a brutal thing to go through. So we will absolutely be keeping Darren in our prayers. Absolutely. Thank you for letting us know and being able to share in this with you. Okay, continue on now, paragraph 3.
From the beginning, investigators from the MSP allowed the House defendants to direct the investigation away from themselves and towards Ms. Reed. The House defendants were a well-connected and close social group with strong ties to law enforcement. The Alberts are a prominent family in Canton, and investigating police officers know them well. The lead investigator for MSP, Michael Proctor, grew up in Canton and resides there to this day. He has been and remains close personal friends with the Albert family. House defendant Brian Albert was a longtime Boston Police Department officer, and House defendant Brian Higgins was an agent of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF. Adhering to the unwritten rule of protecting their own, Proctor and his MSP colleagues intentionally disregarded the obvious and compelling evidence tying the House defendants to Mr. O'Keefe's murder. Specifically, Mr. O'Keefe's injuries were consistent with a physical altercation. He had bruises and lacerations on his face and a deep gash to the back of his head, suggesting that he was punched and fell backwards, hitting his head on a rigid surface. He also had dog bite wounds and scratches on his right arm and forearm. Equally evident, Mr. O'Keefe did not have a single injury consistent with being struck by a vehicle. He did not have any broken bones or even a bruise on his legs, feet, arms, shoulders, torso, back, ribs, or anywhere below his neck that a medical examiner would otherwise expect to find on a person struck and killed by an impact from a 3-ton vehicle. And to erase any doubt, the Commonwealth's own medical examiner, the pathologist who conducted the autopsy for the Commonwealth, concluded that Mr. O'Keefe's body showed no signs of a vehicular strike. Despite that, Proctor and others shielded the House defendants by intentionally sidestepping fundamental investigatory procedures, propelled by the House defendants' false statements, including that Mr. O'Keefe never went into the house. Proctor reported in text messages just hours into the investigation that the House defendants weren't going to get any shit for this because he's, Brian Albert, a Boston cop, and that Proctor was determined to make the investigation cut and dry by bringing charges against the girl. Indeed, Proctor made his intentions clear in writing. Karen Reed had zero chance of skating. She's effed. This pronouncement were a mere 16 hours after Mr. O'Keefe's body was discovered on the Alberts lawn, and Proctor had not even walked into the house.
All right, hold for a second. So a couple things. I'm hearing something on your, like you're hitting something or tapping something on your mic.
Oh, it's my mouse. Sorry.
Like when you scroll or something, and I saw some people in the comments about it. So we'll see if we can fix that. But
yeah, I'll just use the trackpad.
Okay, perfect. So one of the things that's really interesting about this as well is, and why I wanted to read it more than just summarize it, is you're seeing what a lawyer can do. This is almost like an opening statement. That's what it feels like, maybe even a closing argument, because he's using the evidence we already know about, okay? We already know that these text messages exist. We already know this timeline exists. We already know the poor, I just heard something again. Did you do something?
Drop something.
Okay. I'm going to mute you for a second just so you can get it figured out. So we already know that all this timeline exists, but to see it actually in black and white from beginning to end is like, wow, there's a lot here. Okay. There's a lot here. Number one. Number two, when you're getting in front of a jury, one of the important things is if you as a lawyer can get a case in front of the jury and you have a story to tell that is a gripping story and a story that is a winning story. We've talked about this a lot with prosecution cases. When you have that type of a story, and sometimes the causes of action, it's like, is it perfect for this cause of action? Is it this? Well, guess what? Sometimes when your story is good enough, the jury's like, yup, we're with you. You tell us where to check on this verdict form. And so that's why I feel like this story being told is so important, the way that they tell it and how well they tell it. Susan, thank you for gifting 5 Lawyer You Know memberships. Okay, let's keep going here.
All righty. True to his promise, Proctor and his colleagues did not search the house for blood evidence resulting from the gash to the back of Mr. O'Keefe's head, or for fingerprints, or for DNA evidence. Proctor did not search the house despite the fact that Mr. O'Keefe was discovered without a winter coat, without the hat that several witnesses said he had been wearing that night, and without his left shoe. At Proctor's direction, the house was never processed by a criminalist or even photographed. No member of the MSP, including Proctor, set foot inside 34 Fairview for nearly a week. The police did not examine or take evidence from the Alberts' German Shepherd that was in the house on January 29th, a dog that had a history of attacking other dogs and people. Neither
All right, so let's pause again real quick. So, you're also noticing that when it comes to the investigation or lack thereof, the poor investigation is intentional. Intentional. It's not accidental. It's not negligent. They did this. That's what the allegation is here by Reed's team. This is all intentional. They wanted this to be a bad investigation. They did not want to get the evidence. They didn't want to go inside the house. They didn't want to test the German Shepherd because they wanted to cover it up for their friends in this civil conspiracy. Now, will they be able to prove that? That remains to be seen. But this is how this complaint is being written, which is exactly how you have to write it when you see the causes of actions. All right, go ahead.
Neither Proctor nor any of the MSP troopers conducted physical examinations of the House defendants for evidence of involvement in the altercation, such as marks on their hands, knuckles, or face, or bruises on their bodies. They did not seize or search the House defendants' phones. They conducted only perfunctory, unrecorded conversations with Proctor's friends and acquaintances without any attempt to corroborate their stories. They permitted would-be witnesses to communicate with each other and coordinate their stories before any formal interviews. They allowed critical evidence to be manipulated in some instances and outright destroyed in others. In short, by focusing the investigation solely on Miss Reed as implicitly directed by the House defendants through the misrepresentations they made to police, Proctor and his colleagues disregarded and failed to obtain pertinent interviews and other critical evidence from the House defendants that cannot now be recovered or recreated.
Okay, so we pause again. So the House defendants created this narrative, screwed the whole story up, and Proctor was complicit in it and decided not to do his job as an investigator. Iceman said, Peter, since this was filed yesterday, did McCabes and Alberts, was them saying they would sue for defamation due to receiving this? This is a great question, Iceman. I think the answer is yes. They knew this was coming. They tried to get out ahead of it. That's why they made that statement. And in about 6 pages, we are going to stop, take a break, and read the statement their lawyer made as a response to this now that the world is seeing it. But yes, I think they did either already see it and read it or knew it was coming. And I do think that was them trying to get out ahead of it. But that's just me guessing.
Proctor also secretly communicated with the Alberts on his personal phone, deliberately back-channeling those communications to circumvent his state-issued device, and used his sister as a conduit. For instance, on multiple occasions, Proctor disclosed critical and confidential information about the investigation to his sister, who passed that information to her close friend, Julie Albert, Brian Albert's sister-in-law. Julie Albert then passed that same information on to the rest of her family and the House defendants. Part of these communications included Julie Albert's promise to buy Proctor a thank you gift for handling this investigation in a manner that intentionally avoided implicating the House defendants and singularly focused on Miss Reed.
And we know that there was a lot of defenses of, oh, we didn't know, or it wasn't a big deal, or that's not what that meant. And the ho-hum, we didn't think it was appropriate at that time, or we didn't have probable cause to go inside the house. Again, in the trial, Judge Cannoni did not let them dig into that and really make that look as nefarious as it might be. This is going to be completely different. Completely different. Because they're making these allegations, discovery is going to be broad in allowing them to get the evidence they need to prove these facts and causes of action. Thank you, Lisa, for gifting 10 more Lawyer You Know memberships. That's awesome. All right, let's continue. Oh, actually, also important, when he talks about Proctor using his personal devices, we know that Proctor uses personal email. And so those are things that, again, I think they're going to be able to get so much more than they have right now. And this complaint was written just with what we have now, just scraping the surface.
Proctor then went so far as to manufacture evidence to ensure that Miss Reed, not his friends and fellow law enforcement officers, was blamed for Mr. O'Keefe's death. This included planting evidence at the scene on Mr. O'Keefe's clothes and on Miss Reed's vehicle to support the false narrative that Miss Reed hit Mr. O'Keefe with her car, even though he knew Mr. O'Keefe's injuries were inconsistent with a motor vehicle strike and consistent with a physical altercation and dog attack.
It's also important to note that for a malicious prosecution, which are some of the causes of action here, and we're going to get to them and describe exactly what they are, it can't just be a loss. It can't be that prosecutors and law enforcement think somebody did something wrong, they went forward and they lost. That is not how it works. It can't be when that side is actually seeking justice and they lose, you can't file for malicious prosecution. It has to be things like this. They planted evidence. They knew this wasn't the case, and they forced it anyways. They tried to pin it on the girl. They tried to protect their friends. So you start to get the mindset of why we don't get a lawsuit like this every time there's a not guilty verdict, right? That just can't happen. That's not how our judicial system is set up. There has to be specific circumstances and facts that fall into play before you file for a malicious prosecution.
Far from conducting an objective investigation with integrity, Proctor personally sexualized and dehumanized Miss Reed throughout the investigation. Specifically, Proctor's private communications to his high school buddies, sister, and MSP colleagues that he believed would never be discovered exposed the corruption and bias at the core of MSP's entire investigation. Specifically, only hours into the investigation, in a text chain with 8 of his high school buddies, Proctor stated that Miss Reed is some very nice things. Proctor further ridiculed and derided Miss Reed for her serious medical condition, stating that her balloon, some more not nice things, and other private text messages to his MSP supervisors and colleagues. Proctor bragged that while conducting a search of Miss Reed's phone, he was looking for nude pictures of Miss Reed. Disappointed, he reported that there were no nudes so far, in an unfiltered utterance. Proctor revealed that his true mindset, hopefully she ends her life. Indeed, Proctor's supervisors and the MSP knew about and condoned Proctor's unlawful conduct, and in some instances expressly encouraged the flagrant abuse of power. For example, on one occasion, Proctor's immediate supervisor, Yuri responded with a thumbs up emoji to a text calling Miss Reed. Proctor's supervisors and the MSP knew Proctor had a close relationship with the Alberts and that he made no secret of his bias against Miss Reed, demonstrating a clear prejudice against her from the outset.
So there's going to be a cause of action that deals with Buchanan and Tully as supervisors. So that's why it's important that these types of facts are alleged, because without these facts, this complaint would immediately be dismissed because they failed to state a cause of action. You have to put facts in there in order to hook those causes of action. And that's why some of these facts are really, really important to this complaint. Ocean Beach said, to clarify, the new judge, stickler for police following procedure, still needs to accept this third-party defense, correct? Bring on the side bars. So I think what you're asking is this going to be connected to the O'Keefe lawsuit against Karen Reed? Right now, they're in different counties. So in order for that to happen, Karen Reed's team is going to need to file more papers to try and consolidate these claims. They've told us they are going to do that. Just because they said they're going to try to do that doesn't mean they have to. They can still choose to go separate routes. I would expect, because they said that, they are going to try to consolidate all this together. That's going to be a separate motion. We will deal with it in good time when it comes. We're going to stick to this one for now. All right, let's continue.
Relying on manufactured evidence, actively ignoring exculpatory evidence, and without investigating obvious signs pointing towards the House defendants, the Commonwealth secured 2 separate arrest warrants for Miss Reed and a knowingly baseless indictment against her, and then wrongfully prosecuted her for murder twice. As alleged below, these unlawful acts not only underlie plaintiff's meritless wrongful death claim against Miss Reed, but they also form the foundation for Miss Reed's claims against the defendants. These acts violated Miss Reed's state and federal constitutional rights, the Massachusetts Civil Rights Act, and well-established Massachusetts tort principles. On June 18th, 2025, after a 2-month trial, a jury rejected the Commonwealth's theory, in part because the overwhelming physical, scientific, and medical evidence established that Miss Reed's vehicle did not strike Mr. O'Keefe and that Mr. O'Keefe's injuries did not come from a vehicle strike. Although Miss Reed was ultimately and finally acquitted of all charges related to the death of Mr. O'Keefe, Proctor was fired, and nearly every MSP officer in Proctor's chain of command was disciplined for their egregious abuses and misdeeds. The Commonwealth still has not sought or provided justice, not to the O'Keefe family, not to the community at large, and certainly not to Miss Reed.
So that is another important element, okay? Another really important, somebody said you've got Ryan Reynolds reading, John, just so you know, it's a pretty good compliment. I know how people feel about Ryan Reynolds probably in this chat, some of them, but that's probably a compliment. So what's really important as well, when you have a malicious prosecution claim, you can't have been found guilty, right? When your case is what they call terminated, it has to be in your favor in order for you to even have a chance at the malicious prosecution. Okay. So terminated in her favor would be not guilty. And even though some people are like, oh, she was guilty of the OUI, that is not in the death of John O'Keefe, which is what this is all focused on, the leaving the scene, the murder 1, murder 2, whatever else it was, manslaughter, everything else not guilty, right? So take all of that out. She won. And that, because she won the underlying case, that is why it opens up the potential chance of this type of a civil litigation. I see some people saying the civil trial will not be televised. I don't think that has been answered yet, because they're allowing courtroom cameras in the courtroom for the civil litigation portion. Also, people keep asking, who's the guest with Peter? John, producer on the channel, man behind the curtain, helping me read it so that I can react, give my input, and not be drained from reading, be able to follow the chat, and not blow my voice by the end. So John is helping immensely here. Let's continue.
You could have had AI to read it, but you got me instead. So
that is true.
Here we go. In response, the Commonwealth has offered only empty platitudes instead of the solutions. The head of MSP, Colonel Jeffrey Noble, stated, "The events of the last 3 years have challenged our department to thoroughly review our actions and take concrete steps to deliver advanced investigative training, ensure appropriate oversight, and enhance accountability. Under my direction as colonel, the state police has and will continue to improve in these regards." In an interview with the Boston Herald, Noble acknowledged the systemic nature of MSP's conduct in Miss Reed's case. "I'm eyes wide open to a culture issue that I have concerns with as it relates to Trooper Proctor. These hollow words do nothing to right the devastating wrongs that have been visited on Miss Reed." Colonel Noble's words confess a sickness deep in the marrow of the MSP, but offer no remedy, no medicine, no relief to someone so brutally victimized by it. On Wednesday, March 19th, 2025, following the public disclosure of Proctor's illegal and unethical conduct related to the Reed investigation, the MSP's trial board found Michael Proctor guilty of a Class A violation, which included that he was biased in his dealings with a homicide suspect and/or brought otherwise himself and the Massachusetts State Police into disrepute. Miss Reed's life was not merely turned upside down by MSPs and the House defendants' misconduct. It was forever changed by the defendants' transgressions and wrongdoing. The years of uncertainty and unimaginable emotional distress have left lasting scars that will never heal. At the same time, neither Mr. O'Keefe nor his family has received justice. His killer or killers still walk free. By asserting her claims against MSP, Proctor, his supervisors, the town of Canton, and the House defendants, Miss Reed seeks, at minimum, to confront and redress these wrongs and others. More importantly, she seeks to force the Commonwealth to fulfill its duty to stop law enforcement from trampling the innocent to protect their own.
All right, we're going to take a little break. You can skip the parties and jurisdiction. So while he's talking there, we're going to take our first little break here. And instead of getting an attorney comment, because this is the section where they're talking about some of the higher ups making these comments, admitting that there's systemic problems there, I feel like this is a good time to discuss some news out of Norfolk County. Adam Ditch, federal prosecutor, declares run for Norfolk County District Attorney. A former assistant U.S. attorney who had a leading role in the federal investigation into the handling of the Karen Reed case announced Tuesday that he is running for Norfolk County District Attorney, which is Michael Morrissey's job for anybody that doesn't know. Adam Ditch of Quincy left his position as an assistant U.S. attorney for Massachusetts on November 7th to launch his challenge to current district attorney Michael Morrissey. "I left my job as a federal prosecutor because it's clear there's a problem in Norfolk County. Victims are not getting the justice they deserve. The public has lost faith in the system and someone has to do something about it," he said in a written announcement. In his announcement, he touted his success as a federal prosecutor handling corruption cases across the state, including Massachusetts State Police CDL bribery scandal, driving license fraud and bribes, and a fraud case involving Boston community activist Monica Cannon Grant. Ditch also served as a lead assistant U.S. attorney in the federal investigation into the death of Boston police officer John O'Keefe and the state investigation and prosecution of Reed. Morrissey has largely been absent from the public eye since June, when Reed was found not guilty of two more serious charges brought against her in her retrial in the death of John O'Keefe. Morrissey has been the district attorney since 2010. What do you guys think about that? Honestly, in the chat, let me know what you think about that, because while he did lead the investigation into the investigation, no charges were brought, right? Did he have the opportunity to do something like that and he didn't? Why did he make those decisions? Now, obviously, I assume most people there are going to think anybody is better than Michael Morrissey, And it's incredibly interesting that this guy would leave his U.S. attorney's job, which, by the way, being an assistant U.S. attorney is an amazing job that people love, and a lot of them are lifers. As long as whoever the new U.S. attorney is will keep them, they usually love that job. It's a great job. You're king or queen. Like, you have the FBI working for you. Like, it is a really great job. You win 99.9% of your cases, basically. So why would he be taking this job? Why would he say that there are issues there? He has more intimate knowledge than maybe any other person that could run for this job, right? Because most people may have heard something, whatever, but he was in it, reading emails and text messages, seeing what they did with experts, right? So, I mean, that's incredibly interesting to me. I'll read the chat, see what you guys think as we get back to the complaint.
Facts is where you want me to start, right here. Facts comment.
Yep.
Before his death, Mr. O'Keefe and Miss Reed were dating. On the evening of January 28th, 2022, Mr. O'Keefe and Miss Reed went out for the night. They first went to C.F. McCarthy's in Canton, where they had several drinks. They then went to the Waterfall Bar in Canton. There they met up with a group of acquaintances, including Brian Albert, his wife Nicole Albert, Brian's brother Chris Albert, and his wife Julie, Jennifer McCabe, Nicole's sister, and Brian's sister-in-law, her husband Matthew McCabe, and Brian Higgins. The group of acquaintances had several drinks and planned to continue the party back at the Alberts' home in Canton at 34 Fairview Road, the house. House defendant Jennifer McCabe told John O'Keefe that he should come to the house. The group had overlapping social relationships. At the time, Brian Albert was a Boston police officer, as was Mr. O'Keefe, though they did not know each other well. Brian Albert and Brian Higgins were close friends. Higgins was an officer with the ATF. He also was permitted to keep an office at the Canton Police Department, CPD, alongside Brian Albert's brother, Canton Police Detective Kevin Albert. Kevin Albert had a professional and social relationship with Michael Proctor. Brian and Nicole Albert's son, Brian Albert Jr., and his friends were already at the house for Brian Jr.'s birthday. In addition, Colin Albert, Brian Albert's nephew, was present. Miss Reed and Mr. O'Keefe had never been to the house before January 29th, 2022. They arrived in the front of the Alberts' home around 12:20 a.m. Miss Reed was reluctant to attend the party for several reasons, including that she was unsure whether they were at the correct location and whether they were even welcome to the late-night party. Mr. O'Keefe got out of Miss Reed's SUV and indicated that he would check out the party and report back to her. Mr. O'Keefe walked to the front door, garage door area of the house, and entered one of the two doors. A period of time passed without any word from Mr. O'Keefe. Miss Reed, who was still hesitant to join, presumed that Mr. O'Keefe intended to stay, and therefore she left to go home without him. At some point...
All right, so hold on. I want to pause for a second. So you can tell in this that there are some details they just don't know, and they can't know, right? And it makes sense because they're also saying she never went inside. But very clearly saying he went inside, she sat out there, and then she left. So I think it is important to kind of point out what they do know, what they don't know. Jukebox said, no one used their common sense during this investigation, just went right to Karen right away. So this is going to be part of their claim that it wasn't that they didn't use common sense or they were bozos or dumb or negligent, but they intentionally went for her in order to keep the heat off of their inner circle and their friends. Dr. Who said, so John is the adult supervision for now. He is going to have to leave here in about an hour. So we'll see how much we get through because he's got a flight to catch, but we've got him for about another hour. So we'll ride it as long as we possibly can.
At some point after entering the house garage, Mr. O'Keefe was involved in a physical altercation either inside the house or garage. During that altercation, the Alberts German Shepherd attacked him, and Mr. O'Keefe sustained multiple dog bites and scratches on his right arm. He also suffered an incapacitating counter coup wound on the back of his head. Mr. O'Keefe's wound was caused by falling backward and striking a rigid surface. The Alberts garage contains such The Alberts garage contains such surfaces. By contrast, the head wound could not have been caused by a vehicle strike or falling backward onto a flat, cold lawn like the Alberts. Because of their knowledge of criminal investigations, the Alberts, the McCabes, and the Higgins, house defendants, knew that calling for medical care to help save Mr. O'Keefe's life would trigger immediate and irreversible risk of their own criminal exposure. Therefore, at least the five of them had agreed on a simple plan to exonerate themselves and implicate Miss Reed. They would tell anyone who inquired Mr. O'Keefe never entered the house and hide evidence that he was there, including his body. Sometime during the night, they repositioned a Ford Edge vehicle at a spot adjacent to the front lawn, which obscured the view of that area of the lawn from potential passerby. At some point further in the night, they carried or dragged Mr. O'Keefe's body to that same area in the yard, close to where one or more of them later claimed Miss Reed dropped off Mr. O'Keefe earlier that night. The plan was devised to make it appear that Mr. O'Keefe had been struck by Miss Reed's vehicle and then died as a result of exposure to the cold.
All right. We'll pause for a second there again. Somebody said, looking up, said, I'm sorry, who's the witness to this? So a lot of it is how it happened or somebody seeing it happened. You might not have somebody testify to that, but the circumstantial evidence of kind of like who's going to testify that it was raining outside? Nobody, but we're going to be able to show pictures that there are puddles on the ground. So what the defense is saying is we're going to be able to show there was a car here later to block this. We're going to be able to show that his head has this injury, that there's, a ledge type fall and there's a ledge in the garage. There's all sorts of things that you can put together with circumstantial evidence. And that's why I was saying the defense is making inferences from the evidence we already know exists. And they're telling the story the way they want to, which is how a civil pleading should be. I always say this, you should agree with the lawyer that's writing this pleading. And that's exactly how they're setting it up. Will they be able to prove it? Time will tell. Alice said, will Jen's morphing testimony that obviously was curated for the new theory add culpability in a civil trial, a genuine effort to convict? So we'll see. I don't know what's going to be most important, but you better believe all of her prior testimony about, I looked at this time, I looked at that time, and Karen's car was there and there was no body there. That's going to all come in. So much was kept out in trial 2, and Karen Reed still won, but so much was kept out that to me, there's going to be some major differences. Even though this feels like the same exact thing because it's the third time around, there are going to be some major differences in this civil case. Camila said, first time catching you live, love from Italy. I want a pizza right now when you tell me you're in Italy. I could go for some of that right now. All right, let's keep going.
Mr. O'Keefe was either dead when the House defendants left him at the Alberts lawn or he died shortly thereafter. After the physical altercation, Higgins left the house and drove to the Canton Police Department in the middle of the night. He later told investigators that he had to do some administrative work, but then changed his story subsequently, stating that he drove to the station because he had to move cars in the parking lot due to the snowstorm. However, video from inside the station shows Higgins walking down the hallway and surreptitiously entering offices while wearing a hoodie to obscure his face. Surveillance video outside reveals Higgins transporting a large bag from one vehicle to another before driving away. After leaving the police station, Higgins and Brian Albert continued to coordinate their stories by calling each other multiple times in the early morning hours and ultimately spoke with each other on their cell phones at 2:22 a.m. Later, both Brian Albert and Higgins denied the existence of these phone calls. And then when confronted with their existence by a separate law enforcement agent, a non-MSP and non-CPD law enforcement agency, at a separate proceeding, they coordinated the same exact lie, falsely claiming the multiple calls and answers were just butt dials. However, 5 minutes after the Higgins-Albert call, Ms. McCabe performed a Google search on her phone at 2:27 a.m., house long to die in cold, misspelling the first word.
So again, they're using all of these facts in the light most favorable to them. Obviously, we'll see if a jury agrees with all of this, but there's so many things that just look really bad that they're going to pile on. And I think it's all going to be admissible and it's all going to be relevant to prove these claims they're bringing. Michelle said, legally, can she sue Hank Brennan? Prosecutors have immunity, almost absolute immunity. So no, I don't think she's going to be suing Hank Brennan. Is Karen locked into these facts or can they shift the theory after more discovery? They can shift the theory after more discovery. Especially some of the things she's leaving open. Like at that time, we would think this would have to be, or this is what seems to have happened in the house. But then, they find something else out that's different. So there is some leeway as discovery continues and you learn more, because in a lot of these cases, the defendant has all of the information. They have all the text messages, pictures that there's no way a plaintiff can have until they do discovery.
Miss Reed began the search for Mr. O'Keefe on January 29th, just before 5 a.m., when she awoke and realized he had not returned home. She phoned House defendant Jennifer McCabe, who already knew exactly what had happened to Mr. O'Keefe. Miss McCabe insisted that Miss Reed drive to the McCabe's house rather than driving to 34 Fairview Road, which Reed did. The two of them were then joined by Carrie Roberts, and the three of them left the McCabe residence. However, rather than go to 34 Fairview, oddly, Miss McCabe directed them to go back to Mr. O'Keefe's home, where Miss Reed had just come from. After the three of them finally drove to 34 Fairview, after the three of them had finally drove to 34 Fairview, the illogical McCabe-directed route to 34 Fairview was intentional. It allowed the House defendants more time to finish creating the scene and hiding evidence before Mr. O'Keefe's body was discovered on the Alberts lawn and first responders arrived. As they approached the house, with Miss Roberts driving, Miss Reed saw Mr. O'Keefe almost immediately. She screamed for Miss Roberts to stop the vehicle and jumped from the moving car to run to Mr. O'Keefe. She began rendering aid, including CPR. As the House defendants had planned, Mr. O'Keefe's body was discovered in front of the Alberts house near a flagpole and fire hydrant on the left side of the Alberts property, as seen from the roadside. The Ford Edge, which had been parked in a position to obscure Mr. O'Keefe's body in the middle of the night, had been removed.
Okay, so another question a lot of people are having is, why aren't they saying the FBI now? Bev's ruling shouldn't apply. Maybe they're just assuming it's going to be inadmissible and they want to keep it to what's admissible, and another law enforcement agency has already been approved by some other court. It doesn't mean that later they can't try to say it's important to say the FBI. So that's still open. Jukebox said, dang, their theory of John's wounds is pretty much my own theory. I swear someone in charge wasn't thinking clearly. Or, as Karen Reed's team is now alleging, they were thinking clearly and they did exactly what they wanted to do with this investigation and pointing it towards Karen Reed.
While Miss Roberts joined Miss Reed with administering CPR, Miss McCabe did not help or even approach Mr. O'Keefe. Rather, she sat in the cab of the vehicle, called 911, and reported that there's a man passed out in the snow. Despite knowing that her brother-in-law, Brian Albert, a police officer and first responder, was just feet away inside the house, Miss McCabe never went into the house or requested that Albert come down to help Mr. O'Keefe. Rather, as Mr. O'Keefe lay dying in the snow, Miss McCabe stood and watched with no fear, urgency, or even concern for her family members residing mere feet away. The CPD were the first on the scene shortly after 6 a.m. At the time, there was no evidence that Mr. O'Keefe had been hit by a vehicle. In fact, the evidence suggested just the opposite. His body did not show signs of trauma commonly associated with being struck by a car. There were no bone fractures or trauma to his lower body, his torso, or any other part of his body, as investigators would expect from a vehicle strike. Rather, Mr. O'Keefe's injuries were consistent with being physically assaulted to the face and head and attacked by a dog. For good reason, the ranking CPD officer on the scene, Sergeant Michael Lank, opined on a telephone call captured on a dash cam that Mr. O'Keefe looked like he had been in a fight. Moreover, the initial search conducted by Canton police officers revealed that there was no vehicle debris on the lawn at 34 Fairview, let alone any debris at or near Mr. O'Keefe's body. Not a single piece of taillight material was discovered on the lawn that morning or in the roadway, notwithstanding multiple searches and the use of a leaf blower to remove snow. Tellingly, despite the commotion outside, including more than a dozen first responders, 3 police cruisers, and 2 ambulances, a ladder fire engine, all with their emergency lights flashing, and at least 2 civilian vehicles, plus Miss Reed's screams upon finding Mr. O'Keefe's body, no one from the Alberts house, including police officer Brian Albert, ever went outside to see what was happening, let alone help. They wanted to avoid scrutiny from police and police investigators. Sergeant Link was a longtime friend of the Alberts and the first law enforcement officer to enter the house. He spoke to the Alberts and the McCabes pursuant to their plan. The Alberts and the McCabes told Sergeant Link that Mr. O'Keefe had never entered the Alberts house the night before. The Alberts and the McCabes' statement was false. Mr. O'Keefe arrived at and entered the house or garage where he was assaulted, attacked by the Alberts dog, and suffered a fatal injury to the back of his head. Despite Mr. O'Keefe's injuries being wholly inconsistent with the story the House defendants were now telling him, neither Sergeant Link nor any other member of the CPD searched the house to determine whether the occupants or anyone else were involved in Mr. O'Keefe's death. Nor did they request to search the occupants' cell phones, observe their bodies for evidence of a fight, or even secure the scene where Mr. O'Keefe's body was found. They failed to do so of bias. They failed to do so because of bias born of friendship and loyalty in favor of the Alberts and McCabes.
So I'm going to pause again there. So if you remember trial 1, I think it was, where Jackson and the defense team was really trying to set up all the connections, the familial connections, how much love they have for each other, how deep it went with their kids, their sisters, their brothers. I think that's going to be a bigger part of the civil case than it was in trial 2. I think a lot of what trial 1 felt like is going to be more akin to the civil trial than trial 2 was, because trial 2 was just a masterful criminal defense job. And I think this is going to be much more on the offensive like they were in trial number 1. Ashley asked, how would you prepare for the depots of these defendants? Well, I'm trying to keep this stream under 2.5 hours, so I can't really go into too much detail, but you want to be broad. You want to let them talk. You already have so many statements from them. You want to ask them, well, who'd you get them talking? Well, who was there when you were saying this? Who was in the car when you went to their house? And now we can depose everybody. Well, Johnny's mom, Jen, drove me to Lank's house, and now let's talk to Johnny's mom, Jen. Is she going to tell the same story that Jen McCabe did? Whatever it may be. You really want to just get as much information as you possibly can, because you already have their statements that you can impeach them, and you know about what they're going to say. And I'm interested to see how many of them plead the fifth during their depositions. Patrice said, can they get information from Higgins and Brian A's phone company since they destroyed the phone evidence? I don't know the answer to this. It all depends on what was stored and what's available with the phone company. Sometimes we can get old information from destroyed phones. Sometimes we can't. So it really all depends. But the fact that the phones were destroyed and how they were destroyed, in my opinion, is absolutely relevant to the causes of action that Karen Reed brought. So many things, again, that were irrelevant to the criminal case are going to be very big points in front of this jury. Let's continue.
After Sergeant Lank returned to the CPD 3 hours after the discovery of Mr. O'Keefe's body and more than 2 hours after being interviewed at the Alberts home that morning, Ms. McCabe called Sergeant Lank to report that she recalled additional information. As part of the plan to implicate Miss Reed and remove suspicion from the House defendants, she falsely told Sergeant Lank that Miss Reed told her twice that morning, "I hope I didn't hit him." More than a year later, at a separate proceeding, Ms. McCabe changed her story to this topic yet again. In furtherance of the House defendant's plan, Ms. McCabe then falsely reported that Miss Reed outright confessed to hitting Mr. O'Keefe right after she first found him in the snow. Michael Proctor was assigned to the case assigned as the case officer and had primary responsibility for the MSP investigation of Mr. O'Keefe's death. Sergeant Yuri Buchanan was Proctor's direct supervisor. Lieutenant Brian Tully was the supervisory officer at the Norfolk County State Police Detective Unit, and thus supervised both Buchanan and Proctor. In their roles, Buchanan and Tully both knew at all times exactly the extent of Proctor's misconduct in investigating Mr. O'Keefe's death, as described below. From the beginning, Proctor should never have been assigned as an investigating officer, let alone the lead investigator. He grew up and resides in Canton, is a good friend of the Alberts, and had known the family for years. Proctor and Julie Albert, Brian Albert's sister-in-law, had each other's personal cell phones. In fact, just days before Mr. O'Keefe's death, Proctor communicated with Julie Albert about babysitting Proctor's minor child. Proctor's sister, Courtney, was also a close friend of Julie. In fact, Proctor's own mother referred to the Alberts as the Proctor's second family. The existence of these relationships was intentionally suppressed by Proctor and other members of the MSP, including Buchanan and Tully, in an effort to ensure that the House defendants were protected and that Miss Reed's right to a fair investigation and trial were undermined. Proctor, Buchanan, Tully, and the MSP never searched for DNA evidence inside the house, never looked for rigid surfaces that could have caused the gash on the back of Mr. O'Keefe's head, never inspected the House defendants' bodies for indication of bruises or cuts that resulted from an altercation, and did not search the House defendants' cell phones. This allowed potential evidence to be destroyed, disposed of, removed, or simply become unrecoverable. Proctor's, Buchanan's, and Tully's interviews of the House defendants were also outside of the normal protocol. They were all interviewed either at their home, their family member's home, their lawyer's home, in the case of Brian Higgins, their lawyer's office, in the case of Brian Jr. and Caitlin Albert, their place of employment, or over the phone. These interviews were each untimely, unrecorded, and fundamentally designed to protect the House defendants, and the House defendants took full advantage of it.
So again, you can see some subtle and some not so subtle shade thrown at a lot of these witnesses. Ensure said, can they subpoena the feds for evidence they had previously discovered? I don't know what you mean, but they've previously discovered. If they already have it, they're not going to have to subpoena the feds. They will have to turn it over to the other side in this case. They're not going to get documents that are still protected by the feds that the feds haven't turned over in the other cases, I wouldn't think. It's garage, according to Kelly Dever. I had a case where a lawyer, it was a construction defect case, and the lawyer on the other side said garage as well. And I was like, oof, what does he say? And the person that he was deposing, my client, who also happened to be a buddy of mine, was like, what? I don't know what you're saying. It was kind of hilarious. Peter, can they plead the fifth considering they already testified under oath? If it's a question they've never testified or made a statement about, would that allow them to plead the fifth? Yes, they are still able to plead the fifth, even though they have testified under oath previously, if they believe an answer they're about to give could potentially be incriminating. All right, let's keep moving.
Specifically, Jennifer McCabe became the point person for the House defendants in providing their false narrative to investigators. She managed and communicated details about the House defendants' messaging and the investigation itself, including visiting Proctor's and other investigators' private residences, mapping out timelines to coordinate statements with other witnesses, leading group text message chains that were later partially deleted, and planning private meetings at all hours of the day and night. Indeed, these were never the acts of innocent witnesses seeking to help an investigation concerning the death of an alleged friend. Rather, they were predicate acts of a conspiracy among a group of people with a shared goal of deflecting their criminal exposure onto someone else. The remaining group texts that were not deleted or that were recovered later reveal some of their planning. For instance, on the evening of January 29th, Jennifer McCabe texted with her sister, Nicole Albert, that Carrie Roberts, who was present when Mr. O'Keefe's body was found, talked to the cops and kept it simple. Of course, there would be no reason to report back to the other House defendants about Roberts keeping it simple, unless what really happened was more complicated. Proctor, Buchanan, and the MSP never sought these communications. Rather, they were obtained by Karen Reed's defense attorneys' repeated motions to compel access to data on McCabe's iPhone. Later, in group text with Jennifer McCabe and Brian and Nicole Albert, Matthew McCabe suggested having Chris Albert publicize their crafted story to a reporter saying, "Ask Chris to ask some questions. Tell them the guy never went in the house." As an endorsement of the plan, Brian Albert responded, "Exactly." Importantly, the text messages from the House defendants' phones that were ultimately recovered and that provided a window into their conspiracy and misconduct, as well as MSP's unlawful investigation, were not the product of CPD or MSP's investigative work. Rather, based on the media reports raising serious questions about MSP's investigation and the House defendants' role in Mr. O'Keefe's death, another separate law enforcement agency began its own subsequent investigation. That investigation, and not MSP's, resulted in obtaining the House defendants' phones, taking statements from the House defendants, and conducting a separate proceeding, all of which MSP refused to do itself. Indeed, the evidence procured by the separate law enforcement agency's investigation demonstrates the House defendants' conspiracy and unlawful conduct, as well as MSP's bias and corruption. Proctor and Buchanan initially interviewed the McCabes and Brian Albert on January 29th at the McCabes' home at 12 Country Lane in Canton, at which time they again falsely stated that Mr. O'Keefe never entered the Alberts' home. Buchanan and Proctor did not interview Nicole Albert and Brian Higgins until February 3rd, 2022, and did not interview Chris and Julie Albert until February 10th, nearly 2 weeks after Mr. O'Keefe's death, and more than a week after Miss Reed was arrested and charged. Before both interviews, the McCabes and the Alberts continued to coordinate their stories and evidence in group text. Proctor, Buchanan, and Tully likewise failed to conduct a meaningful investigation into the Higgins involvement. When Proctor and Buchanan interviewed Higgins on February 3rd, Higgins presented the troopers with a select set of curated texts between himself and Miss Reed. They learned that Higgins and Miss Reed had been exchanging flirtatious texts and that Higgins reported at least one instance in which Miss Reed and Higgins had kissed while at Mr. O'Keefe's house was mere weeks before his death. Rather than pursuing Higgins as a possible suspect, Proctor, Buchanan, and Tully neglected to investigate the matter further. They never interviewed Higgins again, even after surveillance video revealed Higgins was suspiciously hiding his face in the halls in the parking lot of CPD at 1:30 a.m. on January 29th. The video contradicts Higgins' statements about his actions that night. However, not only did Proctor, Buchanan, Tully, and MSP not investigate what Higgins was doing or what was in the bag, but they went so far as to hide this video from Karen Reed and her criminal defense attorneys for years. Reed's defense did not receive these videos until after Reed stood trial for the first time. And even after the separate law enforcement agency's investigation revealed late-night phone calls between Brian Albert and Brian Higgins, MSP failed to pursue either witness further or seek a full forensic extraction of Higgins' phone or even a simple call log from his cellular provider. When it was revealed that Miss Reed's defense team requested the preservation of Brian Albert's and Higgins' phone in order to forensically image, this request was allowed by the court. Both men got rid of their phones within days of one another. Higgins went so far as to drive to the military base on Cape Cod, remove the SIM card from the phone, cut the SIM card with scissors he brought with him, and destroy and dispose of the phone and card separately in 2 dumpsters, and then drive back home. Their destruction of their phones eliminated the potentially incriminating communications between them and was a direct result of Proctor's, Buchanan's, and Tully's intentional refusal to collect important investigative evidence that would be exculpatory to Miss Reed. Even after learning about the destruction of both witnesses' cell phones, MSP investigators had other avenues they could have used to pursue evidence, such as cellular toll records or simply interviewing Brian Higgins and Brian Albert to inquire about the nature of the late-night communications. They intentionally ignored those avenues as well.
So we'll take a pause there for a second, and we're in the middle of hearing these allegations against the McCabes, the Higgins, and the Alberts. And so I think it was a good time for Ted Daniels reported that there was a new statement from the attorney for Higgins, Albert, McCabe, which Ashley asked the question, and I mentioned off the top, shouldn't these defendants each have different lawyers? I certainly think they should. I wouldn't want to represent all 5 of them. Now, husband and wife, fine if they share a lawyer, right? If the Alberts had a lawyer, the McCabes had a lawyer, and Higgins had a lawyer, that would be more normal. But instead, one lawyer representing all 5 of them said, the allegations made by Karen Reed are entirely false. They're defamatory and without merit. Our clients categorically deny each and every claim. This lawsuit is nothing more than a continuation of a baseless conspiracy narrative that has caused significant harm to the reputations and lives of innocent people. Our clients acted responsibly, fulfilling their civic duty as witnesses, and have participated appropriately in the legal process from the outset. Very interesting to hear those comments. There's still more. While we're reading about them destroying SIM cards and going to military bases and not sharing information and going to the police station with their hood over and moving bags back and forth. I mean, it just looks so bad. Miss Reed's claims distort the facts, misrepresent the evidence, and target private citizens in an attempt to deflect blame. Well, they're suing private citizens, which is actually very normal. But as reported yesterday, we will hold Miss Reed accountable for the harm she has inflicted and the conspiracy she and Aiden Carney, also known as Turtle Boy, have manufactured. Very, very interesting comment from their lawyer. Where's My Stapler said, as big as this case is, how difficult will it be to find a jury for this suit? It's a great question. It's going to be difficult to find a jury that's never heard of the case, but that's not what we need. We need a jury that's going to be fair and impartial and has not already made up their mind with the case. And I do think it's going to be possible. It's easier in civil cases than it is in criminal cases. Usually, I would expect them to get a huge jury pool. It's not going to be easy, but I think they're going to be able to do it. All right, let's continue.
Not only did Proctor fail to probe his friends' stories, he coordinated with them through his sister. Proctor spoke to Courtney multiple times a day and knew she was in a close contact with and providing information to Julie Albert. Julie and Courtney called each other many times between February 1st and 2nd, and at least 67 times between February 1st and September 6th, 2022. For example, as he prepared to question Chris and Julie Albert on February 10th, Proctor told his sister Courtney that the interview was not a big deal. Courtney told Proctor that Julie had been nervous and wanted to give him a thank you gift after the interview. To avoid scrutiny, Proctor instructed Courtney to tell Julie to give the gift to his wife, Elizabeth Proctor. Proctor shared investigatory details with Courtney before they were public. In the same instance, referenced above, when his sister informed him that Julie Albert had been so nervous before the interview. Instead of investigating further, he shrugged it off, laughed, and asked why. But Proctor knew exactly why Julie Albert was nervous. He sought to reassure her by telling Courtney that it was fine, just a quick convo. And then after the interview, Proctor spoke to Julie on his personal cell phone in an unreported conversation. Proctor never treated the Alberts as witnesses in a murder investigation. He treated them like family friends that they were.
Okay, so again, there's definitely some filling into the blanks for the defense there about what Proctor's thinking and why he did things. They're still going to have to prove that. So while the story is well written, there are still some holes that need to be filled in with some of the evidence, but there's definitely some circumstantial evidence that makes it look shady, like unreported phone calls, things like that. Dana said, Peter and John, you should add names and titles. We have them. I'm seeing them down here, but they're just not showing up. I don't know why. John usually would do stuff like that. So that to your windows in the future, a nice practice and eliminates people asking who that is. That is a good point. But John, I need you to focus on reading. So we'll do that for a future video. For now, let's just focus on this. Dana, thank you for letting us know. We will definitely do that in the future ones we do like this. Because I personally like this format a lot more than me reading all 50 pages and answering questions and giving comments in between. I feel like there's more legal analysis to this, less of my voice, but more legal analysis than when I'm reading, because I'm focused so much on the reading part. Sticky Doll said, what are the chances they settle? I would refer you to Alan Jackson at the end of one of those interviews. He's like, hey, we're always open to settle if the other side's going to be reasonable. So my question to you, Sticky Doll, would be, do you think the other side's going to be reasonable? All right, let's keep going.
At one point leading up to some of the interviews, Miss McCabe asked Nicole Albert if she had heard anything about more about the investigation. Confident she would learn more from Julie Albert again through Courtney, Nicole Albert responded, we'll get more info to Tom. Don't want to text about it. House defendants did not want to text about their activities and communications because they tried to hide and or lie about them. For instance, it was discovered in the second criminal trial that Miss McCabe had lied in her sworn testimony in the first trial about not visiting 34 Fairview with Carrie Roberts on January 30th on their way to Michael Lank's house. However, while they did not text about this meeting, McCabe's cell phone location data obtained later by Reed's defense reveals that she did, in fact, visit 34 Fairview just one day after John O'Keefe's death and lied about it. The McCabes, Alberts, and Higgins all told the same false story to investigators in their interviews, and Proctor, Buchanan, and Tully accepted their coordinated statements without making efforts to corroborate their stories. Instead of taking the routine, objective, and necessary steps of investigating the McCabes, Higgins, and the Alberts, Proctor, Buchanan, and Tully focused exclusively on Miss Reed as a suspect from the start of the investigation, despite substantial evidence exonerating her and implicating others, just as the House defendants intended. Proctor seized Miss Reed's cell phone and her SUV within 30 minutes of interviewing her on January 29th. He arrested her 72 hours later before reviewing any surveillance from the bars or ring camera footage, before interviewing exculpatory witnesses, and before the medical examiner's official conclusion that the manner of death could not be determined, and that there were no injuries to Mr. O'Keefe's body consistent with a vehicle strike. Much to Proctor's surprise, though the separate law enforcement agency's investigation, his contemporaneous text messages were discovered. Among them, Proctor texted with his high school friends on the evening of January 29th, the day he began his investigation. He told them that the MSP had already determined the Alberts were not going to receive any scrutiny about Mr. O'Keefe's death, even though the MSP had not at that point visited the crime scene or been inside the Alberts' home, and had performed only a cursory interview of the McCabes and Brian Albert. Proctor told his friends that Mr. O'Keefe had been hit by a car and had not been in a fight, despite the fact that Mr. O'Keefe had suffered no injuries consistent with a vehicle strike. But he did have injuries consistent with a fight and a dog attack. Proctor rejected a friend's belief that Brian Albert, the homeowner of the property where Mr. O'Keefe's body was found, would receive some shit, instead of agreeing with another friend's assumption that you guys, the MSP, are out to make it cut and dry since it involves cops. Proctor revealed that he had already decided he was going to put serious charges on Miss Reed and that she was effed and that there was zero chances she skates. From the outset, Proctor was determined to pin it on the girl.
So you have to just love the play on words and the use of Proctor's text in this, right? And that's how you can tell. I mean, this opening statement, closing argument, there is so much here that was not allowed in the criminal case that is going to make this civil case explosive, and the jury's going to have their socks blown off from the beginning. It's going to be unbelievable. I think this is going to be a longer trial than the criminal trial as well, because there's just so much that I think they need to get into in order to really paint this picture appropriately so a jury can understand exactly what's going on here. The real Melon Lord said, my question is, why are the McAlberts continuing to draw attention to themselves? If I was in their position, I would be doing Homer Bush meme real hard. Well, again, I don't think they had a choice. I think that they knew this was coming. Here it is. We've all been talking about it. We've all been waiting for it. So I think they're trying to get out ahead of it. It's kind of, like you're damned if you do, you're damned if you don't, because people would be like, oh, they're too scared to respond. They're not saying anything, but I don't think they're really helping themselves either. All right.
Proctor's supervisors were aware of his bias and conflicted relationships in this investigation. They didn't have to guess. Proctor told them. He told them he knew the Alberts. Text messages from Proctor to Buchanan and other MSP troopers showed Proctor had decided to focus suspicion on Miss Reed to the exclusion of everyone else. He told the troopers that Miss Reed was, and then he was searching her phone of her. In the text chain, Sergeant Buchanan liked Proctor's text describing Miss Reed as Buchanan received Proctor's text and never reprimanded Proctor or addressed his improper bias and conduct. Because he was determined to put serious charges on Miss Reed, Proctor ignored the fact that Commonwealth's medical examiner could not conclude that Mr. O'Keefe's death was a homicide, determining instead that the manner of his death could not be determined. The medical examiner also refused to conclude that Mr. O'Keefe died as a result of being struck by a vehicle, and later testified at a trial that his injuries were not consistent with a car strike. Proctor later admitted that in his entire career, he had never seen a homicide investigation where the medical examiner could not determine the manner of death. But he remained undeterred in his quest to charge Miss Reed. As he later admitted, the medical examiner's refusal to rule the death as a homicide did not matter to him because either way, Miss Reed was going to be charged.
And this is the way they can use the evidence to have a good faith basis for these allegations. That's where you hear upon information and belief. Like, this is a lot more than you usually have in a civil case, right? Because we've had this case going on for so long and there's already been 2 criminal trials and we've heard from experts. So they have so much information to build on.
Proctor made this investigation cut and dry by manufacturing a case against Miss Reed. A crucial first step was to ensure that the crime scene and evidence was not secured. This was in violation of MSP policy and well-established best practices for critical incident investigations. Specifically, the MSP Crime Laboratory requires proper processing of evidence at major crime scenes, including crime scene photography and evidence processing and recovery of latent fingerprint, footwear, and tire track evidence. Neither the MSP troopers involved in the investigation nor the CPD police officers on the scene secured the Alberts home or the area where Mr. O'Keefe's body was found. The MSP did not take any photographs of the house, including any part of the yard where O'Keefe's body was found, until February 1st, more than 3 full days later. No photographs were ever taken of the inside of the inside or garage of 34 Fairview. This intentional departure from established protocols permitted Proctor and Buchanan to generate false incriminating evidence against Miss Reed and give the House defendants time to destroy the actual evidence. By approximately 2:30 p.m. on January 29th, before he had even met or interviewed Miss Reed or seen her Lexus SUV, Proctor had already ordered seizure of the vehicle at her parents' home in Dighton. By 4:17 p.m., the vehicle was in MSP's physical possession. The vehicle was then towed to the CPD Sallyport, even though the MSP has at least 2 closer barracks and Massachusetts was in the middle of an historic nor'easter. Proctor knew he had more leeway to manipulate evidence regarding the SUV at CPD than MSP's facilities, and he knew he needed to have the evidence in a close proximity to the crime scene at 34 Fairview Road. Before the vehicle arrived at the garage, Miss Reed's Lexus taillight had a minor crack but was intact. The crack occurred when Miss Reed backed into Mr. O'Keefe's car at 5 a.m. that morning, and she was leaving to search for him. That incident was captured on video. Buchanan and Proctor followed the vehicle from Dighton and arrived at CPD at 5:35 p.m., just moments after the tow truck with Lexus. At some point after the vehicle arrived at the Sallyport, the right rear taillight was almost entirely destroyed. Video taken from different angles in the Sallyport shows Buchanan, Proctor, Canton Police Chief Ken Berkowitz, and other individuals near the taillight, but notably, no video captures the taillight's appearance at the precise time it arrived at the Sallyport. The available surveillance the available surveillance video from the Sallyport, as well as a CPD access card swipe log obtained by a separate law enforcement agency, revealed seemingly unfettered access to the Sallyport by a myriad of individuals throughout the evening of January 29th, including just before and just after 5:30 p.m. One or more of them destroyed the taillight, secretly took pieces of it into their possession, and then planted some of them in various places at 34 Fairview and on Mr. O'Keefe's clothes. Knowing that there were video cameras both inside and outside the Sally Port, Proctor and Buchanan worked together to obscure their role in manipulating the right rear taillight, and then ultimately to present false evidence at the first criminal trial. Specifically, Proctor directed Buchanan to secure video footage from surveillance cameras located both inside and outside the Sally Port garage, which he did. These videos were manipulated in two significant ways. First, a critical 42-minute portion was deleted from the footage from the Sally Port front wall camera. The portion from 5:08:02 p.m. to 5:50:50 p.m., which included the exact time Miss Reed's Lexus arrived in the garage. This footage would have shown that the taillight was intact. Second, footage from the Sally Port back wall camera was inverted, which made the right side of Miss Reed's vehicle appear to be the left side, and vice versa. Another camera, main driveway side exterior, captured the back end of the Lexus as it arrived at CPD, but it was too grainy to decipher the condition of the passenger taillight.
All right, hold for a second. So when we talked about these things during the trial, again, they're like, oh, those cameras are always messed up. Well, this is intentional conduct, right? And that's what it has to be. And, you know, we'll talk qualified immunity at some point, right? Law enforcement officers, government officials have qualified immunity. But if you can prove that they violated a clearly established constitutional right, and when we get to the causes of action, you'll see exactly what those mean. But that's why it has to be this intentional planting of evidence, manipulating of evidence, editing evidence, not doing things on purpose as opposed to just a negligent investigation. That's what really is important. And that's what I want you guys to focus on as we're reading these facts, because this is all very different than the criminal case and what they're trying to prove here. Casey asks, will they all be found equally civilly liable, I think is what you're saying, against these allegations? So like, if they have to give her $10 million, will it be split evenly between these defendants? It depends under which claims. Some claims, as you'll see, will be just the House defendants. Some claims will just be Proctor. Some claims will be just Yuri, Buchanan, and Tully. Some claims might be everybody. So it all depends on what money they give for what claims, assuming she gets that far and she wins. All right, let's continue.
The videos from inside and outside the Sally Port and Proctor's request for Buchanan to obtain it was intentionally hidden from Karen Reed and her defense attorneys for more than 2 years to avoid scrutiny. The video was then sprung on them immediately before and during the first criminal trial. One driveway camera's footage was not revealed to the defense until just prior to the start of the second trial. In fact, Buchanan presented one part of the video during his direct testimony under questioning by the assistant district attorney, Adam Lally. Buchanan narrated the video to the jury, correctly identified that Proctor was at the rear of the vehicle, but claimed that he had never approached the right rear taillight area of the vehicle. That testimony, however, was entirely false. As he well knew, the video that Buchanan authenticated as fair and accurate was actually neither fair nor accurate because it had been inverted. Proctor was actually behind the right taillight for a significant period, but because it was inverted, it appeared in the video that he was behind the left taillight. They hoped this would allow Buchanan to lie about this issue at trial without detection. With this video and Buchanan's false testimony at the MSP, Proctor and Buchanan attempted to mislead the jury in order to conceal the tampering with and planting of taillight material.
So again, they're adding in some details there that they say are true, kind of making arguments in this complaint. But I am interested, because I've never really seen this in a civil trial. How are they going to try to use the testimony in a criminal trial? Because again, that's exactly relevant here. It's like he testified to this. They flipped the video. They tried to do this during her criminal trial, which she won. And that's why they did it, to pin it on the girl as part of this malicious prosecution. I think that's going to be very, very interesting to watch.
Proctor and Buchanan also took taillight pieces from the Sally Port, brought them back to 34 Fairview to plant them in the location where Mr. O'Keefe's body was found, and then falsified various documents in an attempt to hide their conduct. In warrant applications to the Stratton District Court and Norfolk Superior Court for searches of Google's electronic records, Ring videos, Miss Reed's phone, Miss Reed's vehicle, cell tower records, and other sources of information, Proctor swore he seized Miss Reed's vehicle from her parents' home at 5:30 p.m. on January 29th, 2022, and had the vehicle towed to the CPD. Reports shared by the Dighton Police Department in 2023 revealed that the Lexus was towed from Dighton at 4:17 p.m. Proctor's assertion that he seized it at 5:30 p.m. was intentionally false to hide the fact that the car was in police custody for 73 minutes longer than indicated in his sworn affidavits. Proctor maintained that false narrative because it would hide the exact time frame when he had the opportunity to remove pieces of the taillight from Miss Reed's vehicle and bring them back to the house so that he could later claim the pieces had been there since approximately 12:30 a.m. on January 29th. However, unbeknownst to him, driveway video from the Reed residence in Dighton and a report written by the Dighton Police Report revealed Proctor's lie and revealed the true and accurate time the Lexus SUV came into MSP's possession.
All right. So again, that just is beautifully written. It's beautifully put together. The way they're just explaining this story, right? If only it would come out this good. It's almost like, sometimes I talk to Pete and I'm like, man, this is how the depot went, or this is how the person testified, or he'll tell me. And we're always like, if only we could just take this down and tell it ourselves, right? And that's kind of what this is the lawyer doing that. Boffle Waffle said, I can hear AJ's sass. So this was written, I think it was probably written more by Seligson, the civil lawyer, but Jackson's name is on it as well. And speaking of Jackson's sass, let's take a little break here, give John's voice a break for a second. And let's talk about the statement released from Alan Jackson and Karen Reed's civil team, as reported by Ted Daniel. Today's filing speaks for itself. It is a meticulously documented civil action grounded in evidence, law, and the Constitution. For more than 3 years, Karen Reed was dragged through a baseless criminal prosecution engineered by individuals who abused their authority, manipulated the investigative process, and trampled her rights. Our complaint lays out in stark detail the malicious prosecution, the conspiracy, the civil rights violations, and the intentional misconduct that these defendants visited upon an innocent woman. Intentional misconduct is really important. That's what all of this is. If these defendants want to answer for that under oath, we welcome it. If they want to, right? As opposed to doing what? Pleading the fifth, maybe? What we will not do is legitimize a threat to file some imaginary defamation case. That threat is nothing more than a desperate attempt by these defendants to distract the public from the very real legal jeopardy they now face. When people start waving around defamation claims to mask their own legal troubles, it tells you everything you need to know. They don't want sunlight. They want silence. Have you ever heard something like that before? What could that also be applied to? Karen Reed spent years fighting for her freedom against a corrupted investigation. Now she is fighting for accountability. And unlike the criminal case, this time the defendants don't get to hide behind badges, back channel favors, or manufactured narratives. They will have to answer in a court of law for every lie, every omission, every manipulated report, and every constitutional violation they committed. Karen Reed is not backing down. Our team is not backing down. Accountability is coming. These defendants can threaten all the phantom lawsuits they want, but the truth doesn't flinch, said as only Alan Jackson can, right? I mean, that's as Alan Jackson as it gets. Thank you, John, for reading all of this. Love from Spain. Yes, thank you, John. It's more difficult than you would think to just sit here and read a 45-page document nonstop. It's more difficult than you think. I remember John used to say to me things like, I have no idea how you read the document and talk like that for 2 hours straight. I don't get it. And I was like, you know what, John, you're right. You know, it would really help. And now here we are. NRS Jenny said, thanks for reading and answering questions about this. It's a lot. I agree. I can't believe I've been watching The Lawyer You Know and Team for 2 years. That's incredible. It's incredible how long we've been doing this and how many of you have been around since literally the beginning. It's so awesome. I appreciate you guys. We love that you guys are here. All right, John's got about 20 minutes left, so let's get through as much as we can with him before he has to bounce.
Proctor also deposited the SUV taillight pieces that he and others removed from the vehicle in the Sally Port on Mr. O'Keefe's clothes. Proctor retrieved Mr. O'Keefe's clothes from the floor of the hospital where he was pronounced deceased. Instead of securing the clothes in a sealed container or bag as protocol requires, Proctor and Buchanan drove them around in his car all day and then placed them in the Norfolk County District Attorney's office for at least 6 days, where they were accessible to Proctor, Buchanan, and any other MSP troopers. Proctor and Buchanan failed to create a log to document the chain of custody of the clothing. Therefore, and by design, there is no record of when, how many times, and under what circumstances Proctor and Buchanan touched, manipulated, handled, or otherwise tampered with that clothing. The MSP Evidence Submission Handbook dictates that chain of custody begins at the time of collection and that the collector seal evidence packages as soon as possible after collection to ensure integrity of evidence items and limit loss of transient evidence. Here, in violation of MSP's stated policies, the chain of custody for all of John O'Keefe's clothing, as well as dozens of pieces of taillight material, does not begin until March 14th, 2022, nearly 2 months after it was collected, when Proctor finally submitted it to the MSP Crime Lab. At some point before providing those clothes to the crime lab, Proctor and/or Buchanan placed pieces of the SUV taillight on them, where they were then identified by the crime lab in 2023. Proctor also planted pieces of glass on the bumper of Miss Reed's SUV while it was in his possession at the CPD Sallyport garage, which he then claimed to have recovered later on February 1st. Proctor planted this evidence to make it look like these shards originated from a cocktail glass that Mr. O'Keefe was holding when he exited the Waterfall Bar. Evidently, Proctor did not plan on Karen Reed's defense attorneys insisting on forensic testing on the glass shards, which showed that they did not match the cocktail glass in Mr. O'Keefe's possession. In fact, the 5 glass pieces originated from multiple different sources. One shard of glass on the bumper did match another piece of glass that had been in Proctor's possession during the investigation. The only way for the glass to have ended up on the SUV bumper is that Proctor planted it there in an attempt to connect the vehicle to the death of Mr. O'Keefe.
Yeah, and that's one of the most damning things, because there's no other explanation I can think of for that. I mean, it's really, really wild. Prixie said, spoliation of evidence. If yes, then when? I mean, we're going to have to see, because the civil case, usually you send a spoliation letter at the beginning of a civil case, and if they don't, then it's violated. You can still ask the court for some kind of instruction because they did destroy it. They admitted destroying it, but this civil litigation wasn't going on at the time. So we'll see how they handle that, but I'm sure we're going to get into a lot of those details. Many other wrongful conviction lawsuits strongly support your core hypothesis. A willingness to sue after acquittal for malicious prosecution is a powerful indicator of actual innocence. Yeah, it's very, very difficult, very unusual. Not a lot of lawyers would ever do it. Even these lawyers, they'd look at it and be like, no, I'm sorry. It's just very difficult to prove, but this is not like any other case we've ever seen. Firecracker, Peter, thanks for covering this. For the last few years, you and Emily have really been the best two at showing why legally this situation is so absurd. Thank you so much for all of the kind comments. You guys are the best. This is the best chat. I've never enjoyed an hour and a half video so much. By the way, we're over an hour, so everybody hit the like button because we are going to continue through and work our way through this as long as we've got John here to read. So let's keep going.
Proctor's, Buchanan's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchanan nor any other member of the MSP issued subpoenas to Ring or any other home surveillance company, and no one questioned any other member of the Albert family about the presence of video monitoring. Proctor and the MSP also failed to track down other important witnesses and evidence. For example, Brian Lowran, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial.
So I'll say Lawfren, Lucky Lawfren. Go ahead.
Sorry.
It's okay.
Proctor and his colleagues never spoke to him during their investigation, and only did so once Lawfren was interviewed by a separate law enforcement agency and provided statements inconsistent with the MSP's narrative 18 months after Miss Reed was already indicted and awaiting trial. Specifically, Mr. Lawfren drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was no body on the lawn at 34 Fairview, nor cars on the street in front of the house at 2:30 a.m. Mr. Lawfren believes he would, believes he would have seen a body and that it would have been in the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30 a.m., Mr. Lawfren saw a Ford Edge in front of the Alberts' home that had not been there an hour before, but which was parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at the time. However, the Ford Edge was gone by the time Miss Reed arrived to the house around 6 a.m., and in its place, she discovered Mr. O'Keefe's body. Proctor, Buchanan, and Tully never made any effort during the actual investigation to track down Mr. Loughran or any information relating to the Ford Edge. Proctor also secretly made efforts to protect other Albert family members during the investigation who may also have had a role in Mr. O'Keefe's death. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28th to 29th. But Proctor omitted his name from the official summary of Miss Nagel's interview, even though he listed all others who had been present at the house with Colin. When Miss Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorialization of the Julie Nagel interview mirrored almost exactly what was typed up in his police report, except for the words Colin Albert.
So again, that's why this discovery is going to be, these defendants are not going to enjoy this discovery. They rarely do in a civil case. So from when we're looking at Colin Albert and what kids were involved and who was actually saying it and who was in Proctor's notes and how did he change his notes? And Jen McCabe said, I didn't say that. How did that get in Proctor's report? Whenever we get through this, it's just going to continue to create inconsistencies. And at a certain point, it's like, is it negligence? Did he just mess it up? Or did he purposely hide and change facts in order to protect the House defendants as they've been called throughout this complaint? Angela said, didn't they say they're going to sue CPD and MSP in total, like 10 defendants? Is there a separate lawsuit coming after them, or Love from Scotland? Is that what that is? Like, the flag is, I'm not the best at world geography. I don't know the answer, right? I don't know who they're going to sue or when. You know, the world is their oyster. We're just going to react to it and read it and break it down whenever it does come. But this is definitely step number one, and it's a big step.
Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationships with the Albert family, as well as propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, a CPD officer, instead of official channels when he coordinated interviews of witnesses, even though CPD was rescued from the investigation. Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin were out together drinking alcohol and driving in Proctor's cruiser on Cape Cod. At the end of the night, Kevin Albert forgot to bring his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both MSP policies as well as various Massachusetts criminal statutes, and further highlights the conflicted nature of MSP's investigation.
Okay, so one of the causes of action talks about how they violate and don't follow the policies and procedures. So that's what's highlighting of this. This is not really intentional conduct, but again, it does kind of describe the relationship between this might be found to be some kind of irrelevant information. Somebody said, how is this different from a 1983 action or lawsuit? I thought I had that, but I didn't star it. So you're going to see the causes of action are 1983. Usually it's in a federal claim and still might end up being if it gets removed to federal court, but it's very similar here. All right, go ahead, John.
Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with CPD in hiding certain videos from Karen Reed's defense team. Specifically, upon information and belief, MPD and CPD collaborated to keep exculpatory surveillance video from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activities in the CPD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. They demonstrated that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Miss Reed. Additionally, upon information and belief, CPD set its auto-delete function for saving certain surveillance videos from the Sally Port to 30 days, therefore assuring the immediate destruction of likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent a defense expert from auditing the footage, which is when the 30-day setting was discovered, or the footage was obtained within 30 days of January 29th and withheld from the defense. Miss Reed was arrested on February 1st, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of the driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. Miss Reed was later rearrested on June 9th, 2022, after being indicted for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 2023, her bail was reduced to $80,000 at the defense request. Miss Reed was tried twice by the Commonwealth. The first trial started in April 2024 and ended on July 1st, after the court ordered a mistrial because of a hung jury. On June 18th, 2025, following another nearly 2-month trial, Miss Reed was acquitted of all charges associated with the death of John O'Keefe: murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen Reed was able to leave court knowing that the forces aligned with her, the forces aligned against her had failed to convince a jury to buy their deception. Beginning in January 2022, the defendant's actions have had profound effect on Miss Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she would be imprisoned for the rest of her natural life for a crime she did not commit.
All right, so we're getting close here. About page 32 is the end of the facts, and then we get into the cause of action. John is good until 5:30. Kelsey's going to put up a poll to see if you guys want to finish this tonight, and once John leaves at 5:30, I will continue reading and finishing it up, or do we split it and part 2 do the causes of action tomorrow? She's going to go ahead and throw that poll up. You guys vote. You guys will decide, but I will let John keep reading.
Miss Reed suffers from both Crohn's disease and multiple sclerosis, as documented under seal with the criminal court. Miss Reed has undergone tens of surgeries to manage her illness prior to January 29th, 2022, and endured a blood transfusion just months before Mr. O'Keefe's death in the aftermath of the charges, 2 arrests, and during both trials. Miss Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Miss Reed underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for those extraordinary damages Miss Reed has suffered in their hands.
All right, hold for a second.
Sure.
Also, if you want to finish tonight, because the chat is saying finish tonight, Kelsey's still going to post the poll. You also have to hit the like button. So I don't know how many likes we're at. Somebody let me know how many likes we're at. We're going to have to be at least at 4,000 likes or something before we finish this thing tonight. So hit that like button, everybody. All right, keep going,
John. Proctor wrote more than 1/3 of the police reports in this case, testified at the state grand jury 3 separate times, interviewed every member of the Albert and McCabe families, had possession, at least until March 14th, 2022, of all of John O'Keefe's clothing and all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevrolet Traverse the day after Miss Reed was arraigned, had access to and reviewed all the ring videos, had access to and reviewed the surveillance from C.F. McCarthy's, had possession of all the CPD Sallyport and driveway videos, and numerous other critical investigative activities. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide him from the jury and sanitize the compromised investigation, while Miss Reed was forced to trial not once, but twice.
Yeah, and I mean, just imagine having all that negativity about the cop that's going to come in front of the jury. Like, look, even his own department knows what he did, and this is how they treated him. Now, will some of that be post-remedial measures? Will the court not let some of that in? I do think there's a possibility that everything is not coming in the civil case and that this judge will still keep certain things out, but a lot more than came in the criminal case. All right, we were at 3,300 likes. Now we're at 3,500. You guys let me know if we get to 4,000. We're going to need to be at 4,000 by the time we're at 5:30, or we'll finish it tomorrow. All right, go ahead, John.
Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7th, 2024, mere days after the conclusion of Miss Reed's first trial. Proctor was terminated from the MSP on March 19th, 2025, upon a release from the district attorney of more implicating text messages from Proctor's phone. On October 18th, 2025, Proctor officially ended his appeal with the Civil Service Commission. On September 23rd, 2024, an MSP internal affairs investigation found Yuri Buchanan failed to perform his supervisory duties in an ongoing investigation. On July 7th, 2025, Buchanan was transferred out of NDAO detective unit and reassigned to an administrative role in another division. On October 18th, 2024, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morrissey to continue detective work on the Reed case despite his demotion because of his behavior on this case. Upon information and belief, MSP troopers David DeCisio and Jeffrey Kotkowski were also disciplined for their misconduct associated with MSP's investigation of Miss Reed.
When you read these, read the counts as well.
Okay.
The titles.
So count 1, malicious prosecution under the Fourth Amendment against Proctor, Buchanan, and Tully. The preceding paragraphs are
hold on, sorry. So if you see 42 USC 1983, these are under the 1983 actions, right? So this is malicious prosecution. This is in violation of Karen Reed's civil rights. All right, keep going.
The preceding paragraphs are incorporated herein by reference. Proctor, Buchanan, and Tully violated Miss Reed's Fourth Amendment rights by engaging in a malicious prosecution of Miss Reed by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal proceedings against Miss Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. Proctor, Buchanan, and Tully caused Miss Reed to be seized without probable cause as described above, including, but not limited to, by leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Miss Reed's unlawful treatment.
So you're seeing now exactly what they have to prove. Okay. So this is what they have to prove. Each element in each paragraph under these causes of action is what they have to prove in order to be successful on each count. So, and you can also see the defendants that it's against: Proctor, Buchanan, Tully. All right, let's keep going.
Handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Miss Reed's unlawful treatment. Violating MSP's rules, policy, and procedures in all aspects of the investigation.
So you see the facts that when they talked about how they violated certain rules and policies and procedures and did not follow them, that's why they allege those facts above, because they have to prove them in these causes of action below. It's a really well-written complaint, in my opinion. The PMOT, thanks for gifting 5 Lawyer You Know memberships. I believe that's Patrick. Go ahead, John.
Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. Failing to secure evidence in the crime scene, obtain evidence timely and appropriately, interview suspects, and investigate the Alberts, McCabes, or Higgins, and allowing them to destroy potentially exculpatory evidence. Failing to consider and present exculpatory evidence to prosecutors in the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm, and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of the lower body trauma. Following her indictment by a grand jury, Miss Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pretrial release provisions. These post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Those deprivations continuing during Miss Reed's second trial, in part because of Proctor's false testimony at Miss Reed's first trial. Among other things, Proctor falsely testified that when he first saw the taillight on Miss Reed's car at at Miss Reed's parents' house in Dighton, it had large pieces missing, and the shattered taillight displayed on the first trial as photographed on February 1st, 2022, was in the same condition as on January 29th. He and Buchanan never touched any part of Miss Reed's vehicle when it was stored in the CPD Sallyport. He retrieved taillight pieces on subsequent searches at the Alberts home when he knew he had deposited or arranged for someone to deposit the taillight pieces at the property. Chris and Julie Albert were his loose acquaintances rather than friends, and his statements and sworn affidavits, all claiming the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were typos. Thus, Proctor, Buchanan, and Tully, acting under color of law, violated Miss Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court for Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to an award of damages for these harms, Miss Reed is entitled to her attorney's fees under 42 U.S.C. 1988, costs, interest, and punitive damages.
All right. You can take off and catch your flight, John. God's work. Couldn't have done it without you. You can pull your version down, I guess, and I'll throw mine up.
We're on page 35.
Say that again.
Page 35 is the page.
Yeah. I've been following along with you. Okay, cool. So let me add mine. All right. Peace out. Thank you, John. Everybody say thank you to John in the chat. He's taking off. We got JoJo gifting 5 more memberships. Everybody hit the like button because, or to thank John. Thank you, John, for that. Couldn't have done it without you.
Hopefully I'll be back sometime soon.
Yeah. Fly safe.
See you guys.
All right. See you. Okay. We are going to keep reading because we got to 4,000 likes. It'd be awesome if we got to 5,000 likes. You guys can keep me posted. That was one of the most fun things ever, to read the chat and see people being like 3.6, 3.7, 3.8, 3.9. So keep me posted if we can get to 5,000 likes. That would be amazing. We are going to go through the next 5 causes of action, and I'll dig in more on these as I'm reading. We wanted to get through as much as we could with John before he had to leave. Count 2 is supervisor liability. So what we're talking about before, but just Buchanan and Tully, because they are the supervisors. We heard the facts that were alleged above. It's not just Proctor. Proctor's the bad guy, but he's the supervisor, thumbs upping the bad stuff that he did, basically. A supervisor is liable under 42 U.S.C. 1983 when the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. So law enforcement officers and government actors are so stinking protected by all this immunity that they're allowed to do so many bad things and not get sued for it. But at some point, we're like, no, you can't do that. You're violating the constitutional rights of the people you are supposed to protect. And that's what we have here. And it's so bad that we want a supervisor to be able to look at and be like, no, Proctor, you can't do that, dude. You're out. I'm taking over, and I'm going to do this the right way and protect these people because I'm supposed to protect and serve. But they didn't do that in this case. Buchanan and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship with, which he had disclosed. They also knew or should have known that there was a grave risk Proctor would wrongly seek to have Miss Reed charged, given the manifest bias evidence in his text messages, which were sent to Buchanan, among others. Buchanan and Tully could have taken easily steps available to avoid a constitutionally deficient malicious prosecution of Miss Reed. Those measures include, but are not limited to, replacing Proctor with an unbiased investigator who had no personal relationship with anyone involved in Mr. O'Keefe's death, safeguarding the crime scene and the physical evidence, including Mr. O'Keefe's clothes and 47 pieces of taillight material, to prevent anyone from planting, manufacturing, or manipulating evidence, initiating timely searches of the Alberts home, and quickly seizing the cell phone and other forms of electronic evidence in the possession of Alberts, McCabes, and Higgins, which would have prevented their later manipulation and destruction of. By not taking any of those measures, Buchanan and Tully permitted Proctor, and Tully permitted Buchanan to violate Miss Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violating Miss Reed's Fourth Amendment rights. In these ways and others, Buchanan constituted condonation, a lot of C's there, of an acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. So akin to intentional conduct. In these ways and others, Tully's conduct condonation of or acquiescence to Buchanan and Proctor's behavior or gross negligence. As a proximate result of these breaches, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death and suffered harm. In addition to the damages, she's entitled to attorney's fees, costs, interest, and punitive damages. Welcome, Dolores. Did Karen Reed get her bond money back? If it was bond, then no. If it's bail, you should get it back. I don't know if it was bond or bail. But if you put up 10%, it's gone, win or lose, which again is just part of the system that really sucks for criminal defendants. We're up to 4.5 thousand likes. Keep it rolling, people. Keep it rolling. Let's go. Signing off, you read way too fast. Sorry, Liza. It's how I read. We got John for an hour and 45 minutes. I read a little bit faster. I apologize. You can always slow it down. YouTube allows you to do that, but I am how I am. This is how God made me. I read very quickly. All right. Another count 3, 1983 action, conspiracy to deprive Miss Reed of her Fourth Amendment rights. Proctor, Buchanan, Tully, Alberts, McCabes, Higgins. Everybody here is involved in the conspiracy. Proctor, Buchanan, okay, all of them shared a common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. As part of their concerted efforts and among their many other misrepresentations, the Alberts, McCabes, Higgins agreed with each other in order to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed's made inculpatory statements on the morning of January 29th. When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Miss Reed. How did they know? I don't know. How are they going to prove it? I don't know. How do you prove somebody's state of mind and what they know? Maybe by text messages, emails, etc. Are we going to get more discovery on that? My guess is yes. Proctor, Buchanan, and Tully knew or should have known that these statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone and anyone else. I think this is easier said than done, right? I really think this is easier said than done, but we'll see. In furtherance of this plan, among other unlawful conduct, Proctor, Buchanan, and Tully agreed to continue to handle the investigation even though they had personal relationship with the suspects in the M, which led to unlawful and favorable treatment of the potential suspects. I think that's true and provable. To continue to handle the investigation even though they had biases against the House defendants. I think they can prove that. To continue to handle the investigation even though they exhibited extreme and personal negative bias towards Reed. I think they can prove that with Proctor text messages. To violate rules, policies, and procedures in all aspects of the investigation. I think they can prove that. To plant, manufacture, and manipulate evidence, falsify documents, and commit perjury. That one, I think they might be able to prove some. I don't know about others. To not secure evidence and the crime scene, they're definitely going to be able to prove that. And to not investigate and obtain available evidence or timely and appropriately interview suspects, I think they're going to prove that. To not investigate the Alberts, McCabes, and Higgins, I think they're going to be able to prove that. So a lot of the facts, I think they're going to be able to prove. But are they going to be able to prove the motivations? Why did they do these things? Was it because they suck at being cops and were negligent? Or because they intentionally wanted to protect the House defendants and go after Miss Reed? That's the difficulty, is proving the motivations. Because they're going to be able to prove a lot of these facts, in my opinion. They look horrible for these House defendants and these cops. The McCabes and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls, texts on their phones, which were later destroyed and discarded. Finally, Proctor, Buchanan, and Tully coordinated with the Alberts and McCabes through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Now, we know there were phone calls. What were they talking about? Right? It's easy to say this is what I think it was, but how do you actually prove it? All right, we are at 4.7K likes. That's awesome. As a result of the conspiracy between and among them, Proctor, Buchanan, and Tully never investigated the House defendants, and instead, Miss Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's M, and the House defendants were able to direct the investigation solely towards Miss Reed because their personal and professional connections to PB&T and their superior knowledge of police and criminal investigation as a result of their own work in and connection to law enforcement. Yeah, so many connection to law enforcement is going to be a big part of this case as well. We're up to 4.8K. Let's go. The proximate result of Miss Reed's wrongful prosecution was her loss of employment. We know the damages now. They've been repeated. We'll see what it ends up being. If they win, I expect it to be a huge, huge number by this jury. Count 4, Massachusetts Civil Rights Act against Proctor, Buchanan, Tully, McCabes, Alberts, and Higgins. So now we're going to hear some state actions. And this is important because they want to keep it in state court because they want to consolidate it, at least that's what they've said, with the O'Keefe's wrongful death lawsuit. People are asking why Lally and Hank wouldn't be here, because the immunity extends further to prosecutors than it does law enforcement. I think it's as simple as that. Honestly, I think it's as simple as that. Proctor, Buchanan, Tully, and the House defendants interfered or attempted to interfere with Ms. Reed's exercise or enjoyment of her rights under federal and Commonwealth constitutional laws through threats, intimidation, or coercion. Who are the defendants here? Everybody. Among other acts, by manufacturing and planting evidence, not securing crime scene, not searching the Alberts' homes and Higgins' phones, and ignoring exculpatory evidence such as dog bite injuries and lack of injuries consistent with the vehicle strike, they all caused Ms. Reed to be wrongfully indicted, arrested, and prosecuted. By falsely representing that Mr. O'Keefe never entered the house, they violated her state civil rights. I'm just trying to see if there's anything different. The wrongful indictment, okay. Moreover, they amounted to threats, intimidation, and coercion designed to force Ms. Reed to give up her defense and plead guilty to a crime she did not commit. She was wrongfully prosecuted, suffered damages, and she's entitled to attorney's fees, costs, and interests. Okay, common law, malicious prosecution. Again, these are similar causes of action, but this is something to try and keep it into in state court as opposed to being removed to federal court. 4.9, we're almost there. The preceding paragraphs get incorporated by manufacturing, planting evidence, ignoring the evidence, not doing a proper investigation. Ms. Reed's indictment, arrest, and prosecution occurred without probable cause. So this is usually a big part as well of the malicious prosecution. You have to prove there wasn't even probable cause, because if there was probable cause to arrest, to indict, and to prosecute Karen Reed, this all can fall apart. And so I would expect the defense of this case to be there was plenty of evidence against Karen Reed. A grand jury felt that way. Bunch of law enforcement officers not named Proctor, Buchanan, and Tully felt that way. Judges felt that way. Prosecutors felt that way. Lally, Brennan, etc. So many people felt like there was more than probable cause to go against Karen Reed, that how can this possibly be a malicious prosecution as opposed to just a case prosecutors lose, which does happen. And that's why these over-the-top facts are so important to prove. These criminal proceedings were instituted but with malice. Okay, you got to prove that, as evidenced by Proctor's, Buchanan's, and Tully's knowledge that it was based on false evidence. So you put this forward to the grand jury, these comments made by the House defendants that you knew was a lie. And you knew if you would have done a proper investigation, if you would have looked at the ME's report, if you would have looked at the injuries, you knew it wasn't true. So the reason you convinced these prosecutors, these grand jurors, these judges is with false evidence that all of you guys got together and pushed forward with malice. That's the way you prove these claims and causes of actions. People are saying we're at 5K. That's awesome. You guys are the best. I had no doubts. I had no doubts with this crew we would get there. You guys are the best. I appreciate it. The criminal proceeding terminated in Miss Reed's favor. She was acquitted of manslaughter and leaving the scene. Again, as we spoke about earlier, this is incredibly important in these causes of action, that the proceedings are terminated in her favor. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body on the location of the Albert property where Jen McCabe would claim Miss Reed dropped him off, Brian and Nicole Albert and the McCabes and Higgins caused Miss Reed wrongful indictment, arrest, and prosecution. They also destroyed and discarded their phones, eliminating exculpatory evidence, and they damaged Ms. Reed. All right, count 6 now. Let's get to this. Welcome to all the new members. It's awesome that you guys joined during this majorly huge stream. I do want to talk 5.1. Who says we have to stop? We got no quit in us. I do want to talk about the Brian Walsh stuff. I really want to bring my dad in to talk about it because he was like, woo. So I really want to do that. I think we're going to do it tomorrow. Just so much going on today. All right, count 6, intentional infliction of emotional distress against everybody. And this one's interesting because it's a little bit different than some of the ones above. So let's take a read. By manufacturing and planting evidence, not securing the crime scene, not searching Albert's home or Albert's and Higgins' phone, and ignoring exculpatory evidence such as the dog bite injuries and lack of injuries consistent with the motor vehicle strike, they caused Miss Reed to be indicted, arrested, and prosecuted. By falsely representing that Mr. O'Keefe never entered the house by relocating his body. Okay, a lot of similar allegations. Okay, here we go. Here's the difference. These defendants knew or should have known that their conduct would cause Miss Reed emotional distress since it would lead to her prosecution for the M and other crimes, and the conduct did cause and is causing Miss Reed severe emotional and physical distress. The defendant's conduct perverted the justice system, allowed Mr. O'Keefe's true killer to escape liability, and threatened to imprison Miss Reed. It is this type of behavior that threatens citizen society and is therefore extreme and outrageous. To me, this is as good of a fact pattern as you could possibly have for intentional infliction of emotional distress. You lie and try to get a crime pinned on somebody you know didn't do it to send them to prison for the rest of their life. If it's true, and if they can prove it, this is absolutely intentional infliction of emotional distress. Absolutely. All right, count 7, civil conspiracy. Again, they share a common design, acted in concert to frame Karen Reed. You know a lot about conspiracy from the Adelson case. Did they have a meeting of the minds? Did they all come together? Well, as a part of their concerted efforts, they had misrepresentations. They agreed with each other to tell investigators certain things, which we've been over. When they made these statements, they did so only because they were aware that Proctor, Buchanan, and Tully would be good to go because of the relationships they had with them. They knew or should have known those statements made by the House defendants were false. Easily obtainable evidence could have demonstrated they were false. They decided to ignore that. I can't remember what my dad called them. It wasn't bozos. It wasn't like the Bad News Bears, but it was something like, some horrible cops. That it wasn't just that. They did it on purpose. They agreed to fabricate, plant, and manipulate evidence purporting to show that Miss Reed's vehicle hit John O'Keefe. Pursuant to their plan, Proctor and Buchanan and Tully carried out multiple overt acts. The overt acts are always important, including damaging the taillight on Miss Reed's vehicle. Will they be able to prove that? We'll see. If they can, which is how we look at complaints, right? We did it this way when it was reversed and it was bad for Karen Reed and a lot of you hated it. Well, guess what? We do the same. We do the same in favor of Miss Reed when she is the one. When she is the one that's filing the complaint. The Keystone Cops. I think that's what it was. Yeah, the Keystone Cops. You guys are the best. 5.2K likes. Let's keep it rolling. So overt acts including damaging the taillight while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th prior to the MSB CERT team's arrival. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. So, how did the shards of glass get in the shirt that John O'Keefe was wearing? Well, they have their theory here. Will they be able to prove it? And they don't have to prove it beyond a reasonable doubt, just by the greater weight of the evidence. Proctor also deposited glass alleged to have been from a cocktail glass on the bumper of Reed's Lexus. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like the Alberts and the Higgins. They coordinated through text messages, phone calls, etc., to have these conversations. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabes and the Alberts in a cursory manner the morning of January 29th. The entire way, how and where and when these interviews took place is all part of the conspiracy, according to Karen Reed and her team. Pursuant to the coordinated plan, Proctor, Buchanan, and Tully did not search the Alberts' phones or home. We've been over a lot of these facts. They agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Reed's car as a part of this common plan. Higgins and Albert, both law enforcement officers familiar with the investigations, communicated at 2:22 a.m. on the 29th after they left Higgins' house. You know, the old butt dials. Shortly thereafter, as part of the plan, McCabe deleted a Google search. We know about the house long to die in the cold. I mean, it's just almost too perfect. right? It's just almost too perfect how all of this happened. Lisa, you're the best. Thank you for gifting 5 more Lawyer You Know memberships. And this defense team is going to have all of this to work with when they say this is how it happened. They acted in unison and had a peculiar power of coercion over Miss Reed because they were state police employees investigating Mr. O'Keefe's death. They had superior knowledge of police and criminal investigations as a result of their own work and connection to law enforcement. Just perfect for this conspiracy. And they worked in concert in this conspiracy to inflict emotional distress on Miss Karen Reed. They want a jury trial. And what are they asking for? Well, they're asking for the court to enter judgment in favor and against each relevant defendant on each count of the complaint, award her damages in amount to be calculated at trial along with pre- and post-judgment interest, costs, and expenses, award her reasonable attorney's fees incurred in connection with this litigation pursuant to 42, Section 1988, and other applicable statutes or law, and grant her such relief as the court deems equitable and just. Damon Seligson and our boy, Alan Jackson, Pro Hoc Vice, filed yesterday, November 17th, 2025. Woo! 2 hours. We just broke 2 hours. If you haven't hit like, which over 5,000 you have, hopefully you hit it now. That was fun, guys. That was a long one, but thank God for John, or I would not have been able to make it through it. I'm already sweating just from reading those last 10 pages. We are not done, right? We've got a lot still to discuss, especially in the Brian Walsh case. A lot of you have asked, we're at 5.4K. That's awesome. A lot of you have asked about the judge in Lori Vallow's case, maybe breaking down the interview he did with Nate Eaton. I'll have to check that out. But I'm starving now. Feel like I've got low blood sugar. I need to go eat something. You guys are the best. I appreciate you so much for being here. I do not take it for granted for those of you that sit around and listen to us read boring legal documents, and you make it so interesting, educational, and entertaining with your questions and your involvement. So thank you guys so much for hanging around for this. Thank you for hitting the like button. Thank you for continuing to show up and ask me questions and send me these complaints and documents that you want broken down. You make it so much enjoyable from my side of the camera, and I won't forget it or take it for granted. So thank you so much. Until next time. Yeah, special shout out to John tonight and Kelsey. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.